Legally Speaking with me, Tarun Nangia. Every day when you open the newspapers, you can read about some of the other matter that the Enforcement Directorate is pursuing. Many times these are involving high-profile people, involves violations of FERA also the offense of money laundering. Today, I'm going to speak to Advocate Abhimanyu Bhandari, who's penned a book which is essentially a critique of the Money Laundering Act. According to him, there should be changes in the law. For those of you who want to buy this, it's published by LexisNexis. This is the book that I'm holding in my hand. This is a critique of the Prevention of Money Laundering Act. And today, Advocate Abhimanyu Bhandari is going to explain what he thinks of this law. How is this law seen from the international perspective by investors abroad? And we'll get a wholesome view on where he thinks the law ought to be amended. Of course, we know that there are cases in the Supreme Court also where there is a demand to have the law amended or certain sections to be read down or struck off. But all of that we will discuss in the course of the show. Mr. Bhandari, good to see you.
Thank you.
And at the outset, you wrote this book, and what led you to write this book, A? And secondly, could you also share with us what is the offense of money laundering all about?
Thank you, Tarun. Tarun, what led me to write this book was during the pandemic, I started thinking a lot about this law because, classically before the, in the early 2000s and even in the mid 2000s, I spent a lot of time doing commercial and corporate matters, and I was really an arbitration lawyer, and I was doing a lot of civil law, which I still do. And then suddenly I saw that a large number of my clients who and business houses started getting notices and started getting somehow embroiled in various aspects of dealing with this particular Prevention of Money Laundering Act. And increasingly, I found that investors and corporates started coming and asking for advice. And then I started studying this law in great detail. I found it a very interesting area of law because, for the first time, we've had this money laundering legislation that's not only come in, but actually has been now implemented, and there is an investigating agency and there are cases that are being registered regularly. So that led me to do a thorough research on this book. And I and my colleague Kartika Sharma, who's a co-author of this book, we thought, let's write a critique. Let's not just say what the law is and reiterate the provisions of the law, but let's try to write a critique by also looking at similar provisions in other acts in the UK and in the US, and then see that how we have framed our money laundering law and what changes one could bring in to make it a much better act, not only from the perspective of an investigating agency, but also to ensure that innocent people are not harassed. Because remember, the Money Laundering Act, whether it's in India, in the UK, or in the US, or anywhere, gives copious amounts of discretion to an investigating agencies to go about attaching assets, arresting persons, sending them notices, doing raids, seizures, and searches. So therefore, it was a very interesting area as a constitutional lawyer to kind of see that what safeguards are there in this act to ensure that innocent people who necessarily have not intentionally and knowingly interacted with a money launderer get stuck up and embroiled with this act, and that led us to write this book, and then we published this book going through various provisions of the act and comparing it not only with the UK legislation but also at times with US legislation.
Now, could you explain it for the viewers that basically what is the offense of money laundering? If you can say, explain in brief.
Yes. So, Tarun, this is the heart of the big debate that is right now going on, and which has seized not only various high courts but also the Supreme Court. Really, what constitutes money laundering is the big question. Remember, this is an act which prevents money laundering. So therefore, the purpose of the act is to catch the money launderer and to ensure that the laundering of the money doesn't happen. This is not an act which deals with proceeds of crime. And I'm going to spend a minute trying to differentiate between the both. Money laundering is an activity. So for example, let's take someone who goes and steals 2 bars of gold from a bank locker. Now, this person goes to the bank, he robs the bank, or and takes out 2 bars of gold, and that 2 bars of gold is lying in his pocket. Now, he will, of course, be charged and tried with the offense of robbery, cheating, dealing in stolen goods, etc., etc. But where does money laundering kick in? Money laundering kicks in when that offender or that accused who's stolen those 2 bars of gold from a bank now tries to hide those 2 bars of gold by either selling them to someone else, converting it into cash, and then, let's say, for example, buying a car out of that 2 bars of gold, so that he tries to conceal the transaction and he tries to show that, look, he launders this money to make it really legitimate money. So what he does is, for example, he sells this gold, takes cash, and then he enters into a sham transaction with someone else who says, I'm giving you this money for services that you've provided when you provided no services. So for example, let's say that a person who has a lot of money, stolen money, wants to somehow put that money back in the system and show it as a legitimate income of his or legitimate earnings of his. So what he does, he takes that money, he enters into a contract with someone else where he says, look, I will give you architectural services, for example, right? So, but he's actually providing no architectural services, and he gives him cash to this person, and that person transfers check to his account. So that is money laundering, where what that person is doing is that he bought the gold, sold the gold, took the cash, and then that cash, he gives it to someone else who gives him check money, which he puts in his account and shows, look, I got this money because I provided architectural services to someone. So these are not stolen goods. This is what is money laundering. To put it in the terms of the statute, it says where you try to project tainted money as untainted money, which means what you're trying to do is you are trying to conceal the stolen golden bars as money in your account, converting it into in your account through a web of transactions by showing legitimate transactions you've entered into with people. So that is what is called money laundering. Now, there is a difference between that and merely possessing or using proceeds of crime. So for example, a person, let's say, who has taken a loan from a bank, yes, and he uses that money to buy a car, or he uses that money to buy a house, then he's using the proceeds of crime. There is no money laundering there. Money laundering is when he's trying to project it as untainted money. Now, there can be a huge gap, but you have to be very careful in seeing where there is money laundering and where there is mere use of proceeds of crime. Now, according to me, the act is not an act to catch proceeds of crime. We have other pieces of legislation in our country which catches proceeds of crime. This act catches money laundering. So when the accused person who has stolen some money is trying to launder that money, or when that person has received some money, let's say by way of a corruption activity, or he has done by way of illegal gratification, he tries to hide that money by taking steps, and he tries to convert that money into legitimate source of income. That is when money laundering comes in. So there is a huge difference between money laundering and mere possession and use of proceeds of crime.
Thank you for explaining the difference between the act of laundering money and merely the use of proceeds of crime without laundering it in a sense. So I want to understand from you, because you do a lot of these matters where you have defended people accused of money laundering. Do you come across any cases where assets that are not bought from proceeds of the crime, even they get attached by the enforcement directorate? Are there any instances of such activity?
Yes, many instances, Tarun, and that is because the act is a little ambiguous, to put it mildly. The problem is that the act in one place says that what you can attach are proceeds of crime, and proceeds of crime is defined as monies which are directly or indirectly obtained pursuant to a criminal activity. Now, let me give you a very simple example. For example, let's say that I cheated a bank, or someone cheated a bank, took some money out of that bank and bought gold bars, right? Now, that can be attached because that is proceeds of crime. What you did, you went to the bank, you got some money illegally by making a misrepresentation, a fraudulent misrepresentation to the bank, and then you have that money with you. So in the form of gold bars, or you use that money to buy a car, and therefore that is what is called money laundering, and therefore that can be attached. But then the act, while defining proceeds of crime, says and uses the word, it says that if and tries to say that you can also, if you can't find that money, then you can attach equivalent value of that money. So for example, if X has stolen the gold bars, let me keep to that example of gold bars. If stolen those gold bars, and when you search him and raid him, you see, but those gold bars are not with him. Where are those gold bars gone? So what you can do is you can trace what he did with those gold bars. If he went and used those gold bars to buy a car, you can attach that car. There is no harm in that. But I think what is happening is that we are giving a very broad and a wrong interpretation to these words, equivalent value of the proceeds of crime. That allows a person, that allows an investigating agency to say that, look, I couldn't find the gold bars. I can't find what he did with the gold bars, where that money has gone. I can't find any asset equivalent to those gold bars. So what I will do is that he bought from his legitimate earnings some other asset. So I'm going to attach that. In some cases, even he may not have bought that legitimate, that asset. He may have had a transaction with someone else, or some family member of his may have bought some asset. But because he may have given that person some gifts over a period of time, you go and start attaching that person's assets. So what happens? It gives a very broad meaning to the term value there.
Have you also noticed or come across any instance where the attachment of assets is far in excess to the case under which the accused is being prosecuted? If I want to ask you that if he's accused of laundering, say, 20 crores, the asset attached is, say, 25 crores or 30 crores or 50 crores. Do you think even that happens?
No, that is, you have to see who the accused is. The person who's the main offender, if his assets are being attached, that is fine. Where the problem arises is that, let's say that person has dealt with the worldwide, because you must remember that money has no color. Money keeps changing hand. And therefore, if you start attaching assets in the hands of other people, then that creates a problem, because there may be innocent people who will get roped into this. For example, yes, sure.
I want to ask you, increasingly, we see that if somebody is arrested under this offense, he remains in jail for about a year or 18 months before he gets bail. Why is it so difficult to get bail and if you are prosecuted under PMLA? Because you're presumed as innocent until you're held guilty by the courts of law. So then why is it difficult? Because many times the accused are businessmen. Even if they get out, they are going to carry on their business activity. So when they are inside, business collapses, but a lot of their employees also get affected. So, I mean, there is a ripple effect for an arrest. Could you explain this to us in detail?
Yes. Now, you see, Tarun, we have a very, very large body of jurisprudence dealing with bails in cases of economic offenses. The PMLA Act, when it came up, it had a condition which was very rigorous. The condition really is that you can only get bail if the court is satisfied that you have committed no offense, to put it in more easy and normal language. Now, such a condition is not possible to implement, because a court which is granting you bail is granting you bail at a time when probably even charge sheet has not been filed. And even if charge sheet has been filed, it is you have to argue for bail when trial has not started. So how can a court of law be satisfied at that time whether the person is innocent or has committed money laundering? So therefore, such a high rigorous condition to say that you will only be granted bail if the court is satisfied that no offense of money laundering has been committed makes getting bail in such cases absolutely next to impossible. So when you said people have been behind bars for 1 year, let me tell you, till a particular judgment of Supreme Court came called Nikesh Tarachand, there were people languishing in jail for more than 3 years for offenses of money laundering. And then thankfully came this great judgment of Nikesh Tarachand by Supreme Court, where Supreme Court said that, look, this condition doesn't make any sense. It is arbitrary, disproportionate and illegal, because really what purpose it is serving? Let a person, remember, money laundering is a 7-year offense, just like cheating or any other thing, any other offense. So why should one not get bail so that he can work hard on his trial and prove his innocence before a court of law? After that judgment came in and struck down that condition, then a lot of people started getting bail. Even after that judgment, getting bail was really only practically was only happening in cases after charge sheet has been filed. And you must remember that the investigating agency has 60 days to file a charge sheet. So minimum a person, if is arrested, was spending about 60 days before he was even being able to try and get bail in a money laundering case. Now what happened is, after that judgment, and that the act was again amended, and in another form, the twin conditions came in. Now, this, of course, has been challenged again in the Supreme Court, and we are all waiting for the decision of the Supreme Court as to what the Supreme Court has to say about it. So I think the law in this area will be clarified for once and for all once the Supreme Court decides a batch of matters which is pending, and I think judgment should, it's reserved for orders, as to whether those twin conditions, which according to me and personally are very draconian in nature, have they again come back, and can they continue to remain in the statute book? Because if they have come back with their full rigors, then again we will get back to the stage of pre-Nikesh Tarachand, where people used to spend a lot of time before they could even have a hope of getting bail under the Money Laundering Act.
I want to ask you two more things which are linked to this. That what changes would you want to be made in the Prevention of Money Laundering Act with regards to bail, with regards to attachment of assets, or with regards to possession of assets? Because we read in news many days that this asset, the ED has taken possession, or the accused's assets have been taken into possession. What implication does it have, and do you think that such kind of provision should be there in the Act?
Now, first, bail. Bail, I think, is a fundamental right, and I think that we have moved on a lot, and therefore now the time has come for us to make bail in economic offenses similar to bail in any other IPC offenses. I personally feel that there should be no rigorous conditions imposed when one is asking for bail in an economic offense. Let me tell you, just 2 days back, there's a judgment of Supreme Court called Antil, which in a way says that you can't just deny bail to economic offenders on the pretext that they are of a different category altogether and therefore they should be treated in a separate way. Certainly not. They also have a fundamental right to get bail as easily and as quickly as a person accused of, let's say, cheating, or let's say, robbery, or let's say any other basic offense under the IPC, which has a term of 7 years. And we have a huge body of jurisprudence which says that if you're accused of an offense of up to 7 years, then once charge sheet is filed, then you must get bail, because you should be able to argue for your innocence and you should not be kept languishing behind bars. I hope and pray that this jurisprudence continues to evolve in this manner, and getting bail in PMLA is not seen as something, oh, bail in PMLA means no bail. We need to get out of that kind of mindset. And there is a number of very good judgments of various high courts in the country which have given bail to accused in PMLA offenses, and have said that there is no purpose in keeping a person behind bars once at least a complaint, or in the ED parlance, it's called a complaint and not a charge sheet, which the ED files after completing an investigation. So that's once that is filed, then of course you please go and get bail, because remember, ED also has the power to attach proceeds of crime. So no one is getting prejudice here. By that time, ED is also attached significant amount of proceeds of crime which it can find. So there is no harm in letting that person come out, because for all you know, he may be an innocent person. And I think that we need to make the Act very clear by doing away with those twin conditions, because the confusion keeps arising whether those twin conditions have revived or not revived. That is a change as far as bail conditions are concerned. As far as the other provisions of the Act is concerned, it will be a very detailed show, Tarun, but so I'm just going to highlight 1 or 2 points. One aspect which is creating a lot of problem, as I mentioned earlier on in the show, is that the power to attach equivalent assets if you can't find the actual proceeds of crime. Now, yes, please go ahead and attach those assets which were converted from the proceeds of crime. So for example, if the gold bars were converted into a laptop, attach the laptop, converted into a car, attach the car. But that provision cannot be used as a roving eye inquiry to attach assets of an accused or other persons who have dealt with the accused, which have certainly not been bought with those gold bars. For example, if an accused person bought a house in 2006, you can't attach that house in 2006 if the money laundering happened in 2018. because the proceeds of crime were generated in 2018, which were laundered. So therefore, you have to find those proceeds of crime and attach, and you can't attach an old asset of his which he has bought from his own savings and his regular income. So that is a big issue that the courts are facing right now. The other issue that the courts are facing is and within this is when there is no proceeds of crime generated. And I'm telling you, I've done cases where there have been no proceeds of crime pursuant to a criminal activity. For example, there is a very interesting case which is a very good precedent now, called Jharkhand Ispat, where a coal mine was given to a company, but no mining happened. So no proceeds of crime was generated. But the investigating agency attached the share application money that came into the company. Now, it's a company, it will of course receive share application money, but that share application money is not a proceed of the crime. The proceed of the crime is the illegal allotment of the coal block which the company has got. So really what you have to see is whether that coal block was mined, and if it was mined, were illegal profits that came to him, you could attach that probably, but not share application money which investors have invested in the company, because that would create a completely draconian situation. No investor is complaining that I have invested in an illegal company. There's no complaint from that investor saying that, look, my share application money should not have been taken from me. So in that scenario, they attach the share application money. Thankfully, the PMLA tribunal set aside that attachment and said, sorry, relying on Himachal EMTA, which is a case which I argued of Delhi High Court, and I think it's a watershed in this area of jurisprudence, where Delhi High Court had also quashed a provisional attachment order because no mining had happened, so no proceeds of crime was generated. So, these are issues. So therefore, we need to bring in appropriate clarification and explanations to ensure that this word value thereof, or equivalent value, is better described so that innocent people are not harassed and assets which are not obtained from money laundering is not attached. Now, of course, judicially, we've seen judgments doing that, but I think we need legislative intervention to ensure that the legislature clarifies this entire area of law, because we again and again see number of attachments where property attached is not obtained from the criminal activity, but isn't property obtained long back. I'll give you a very, very interesting example, Tarun, and this emanates from the facts of this Axis Bank case, which is now pending in the Supreme Court, as far as I remember, final adjudication. There, one person was probably alleged of indulging in some demonetization issues where he was converting old notes into new currency by depositing in bank accounts and all that. So one could not find the money he had generated from that. So ED attached a car which that person had bought much before the Demonetization Act came in. Now, the problem was that that car which he bought was by way of taking a car loan from a bank. So the bank came and said, sorry, I have a loan on this car. It's hypothecated to me. How can you take this car away? I have a security interest over this car. And let me tell you, the bank went on fighting. Now, please remember, car is a depreciating asset. So what you've done, you've not only jeopardized the car, forget the car and forget the main accused, but a poor bank which had given a loan way back to this person to buy a car gets embroiled in this whole litigation, and he's not able to recover his security interest. So assets mortgaged to banks by companies, large power plants, large mining, you can't attach that, because we must remember that secured lending is the edifice on which any economy, a modern economy, builds itself. And if we allow this act to walk over certain very basic principles of law or very basic entrenched security interests, then this can create a larger economic issue than anything else. So according to me, we need sufficient clarification in the act to ensure that the attachment or that the proceeds of crime is further defined as to what is equivalent value if you can't find the proceeds of crime.
I want to ask you, Abhimanyu, one question, which will be my last question on the show today. You spend a lot of your time in London. You understand the business environment. At a time when we are looking to get a lot of investment from UK, US, and other countries all over the world, they also study laws in the country. Do you think that this somewhere would be figuring in their discussions that if there is a case under money laundering where we are booked, we're going to have a tough time? Do you think it somewhere also impacts business in the country.
See, Tarun, Lord Wilberforce in a very interesting case called R versus Via in UK House of Lords, which was deciding on, again, a Proceeds of Crime Act issue similar to money laundering, said that this legislation could be an overkill. And increasingly, not only UK, US, everywhere, we see a number of academic literature on this, criticizing various parts of this whole mechanism of Money Laundering Act in various countries. If this is, we as a country should ensure that money launderers are caught, money laundering as an activity is curbed, but we need to ensure that there are sufficient checks and balances so that foreign investors, when they invest in India, or domestic investors, when they invest abroad, can do it with sufficient confidence that they are not going to get embroiled in any technicality of this legislation. And therefore, we need to ensure that there are provisions in the Act which provide protection to innocent investors and innocent businessmen. For example, under the Proceeds of Crime Act in UK, under Section 329 2C, there is a provision which says, and this is a very good provision, it says that whoever has dealt with any money launderer, but let's say he's taken money from a money launderer for adequate consideration, or has bought property from a person accused of money laundering for adequate consideration, then that person cannot be embroiled into money laundering. You can't go to that third party and now start charging him for money laundering and attaching his property, because he's paid adequate consideration for what he has bought. So therefore, we need a similar worded provision immediately in the Money Laundering Act to clarify this. Of course, there is a way one could argue that no, the Act still has those safeguards, and one could argue that before the adjudicating authority. But I think we need a similar provision like 329 2C of the Proceeds of Crime Act in the UK, which uses the word adequate consideration and says, look, if any person has acquired any asset, which is proceeds of crime, by paying adequate consideration, then that asset cannot be attached. That is one very significant change we need in the legislation. Or without this, it creates a lot of litigation. One goes to the adjudicating authority, then to the tribunal, then to the High Court. It also disturbs someone who's actually spent good money and given good consideration. How would he know that that person could in future do money laundering, or that person could be? Please remember, the ECIR, which is a document equivalent to an FIR, is never disclosed in public. So when you're dealing with why, let's say if you have to go and buy, if I go and buy someone's watch or someone's car, I don't know if there is an ECIR pending against that person. With some search, you can at least find out if there's an FIR pending against that person, that also with some difficulty. But to find out whether there is an ECIR, that means a case against money laundering pending that person investigation, is something next to impossible to find out. So therefore, given this, we need to ensure that there are sufficient checks and balances to ensure that third parties who may have innocently dealt with someone accused of money laundering is protected adequately if he has given adequate consideration.
Thank you for sharing.
Another thing, Tarun, before you this thing, we also need to think of bringing in a mechanism by which, if a disclosure, if you're doing a large transaction, let's say X is buying a big property from someone, he should be able, there should be a window where which he can go and under the Income Tax Act, you can go and take a NOC from the income tax authorities when you're buying a property from a company. Because income tax tells you whether they have a lien over this or not, or whether they are unpaid taxes, which gives the government right over it. That way, there needs to be a disclosure mechanism where one can go and disclose that, look, I'm doing this transaction. Please tell me whether there is any issue pending or not pending. And within a time-bound manner, he should get a response from the agency so that that person can then enter into a transaction with confidence.
Thank you for sharing these views. And ladies and gentlemen, if you want to know more on what Mr. Bhandari has spoken of what changes he thinks should be made to the law, you can go and buy a critique of the Prevention of the Money Laundering Act 2002. It's published by LexisNexis, as you can see. And of course, Mr. Bhandari, you argued this matter before the Supreme Court, which asked for certain amendments. The judgment is, the order is reserved. I think the judgment will be delivered soon. We expect it to be delivered no idea, but
I have no idea, but yes, I was one of there were a number of councils, and I was one of them, and I did make some submissions on various areas of law, aspects of the Money Laundering Act.
Okay.
And we all are waiting for that judgment. And I'm sure that when that judgment comes, it will clarify a lot of the arguments which have seized a lot of judicial time all around the country.
Looking forward to that judgment, and then again, if you give time, we will like to interview on this. But thank you so much for sharing your time with us and your opinions. Thank you so much, viewers, for tuning in and watching this very important topic, because this involves all of us, because this involves money, jobs, investments. And if a businessman is arrested, it's not the businessman who's arrested. The person who runs the company is arrested. So employees, production, banks, everybody get involved in this. It's not a simple case of arrest of one person if that person is a promoter. Thank you so much, Mr. Bhandari, for sharing this. Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.